So I want to thank everybody for coming out today. Today, the Georgia State Senate Democrats have submitted a true tort reform bill, the Pro-People, Pro-Business Act, which brings together the important and related interests in protecting people as they look to buy their groceries or be entertained and protect business from frivolous lawsuits. It is reflected in now what is SB 223. This bill does not close the courthouse doors or place unnecessary impediments to people receiving compensation for legitimate claims. It ensures that businesses are protected from frivolous lawsuits. Specifically, how does it do that? It does it in a few ways. One of the critiques of the CVS case was it appeared, although not accurate, that if your business was in a place of high crime, that alone would allow you to be sued. Our bill actually clarifies that and says it is affirmative defense to any claim just because you're in a high crime area that would not allow a person to sue you. So even though the case did not say that, our bill clarifies if your business, if the only reason to be sued is that you're in a high crime area, that would not be a reason under SB 223 that can sustain a lawsuit. Another issue that was brought up was that what if a business owner had never had a problem before? How do you deal with that? We have made that also an affirmative defense. So if a business owner has never had an issue before, that is affirmative defense that he can actually claim against a potential litigation. What this does is really start cutting off frivolous litigation, not legitimate litigation, but frivolous litigation by establishing an affirmative defense. It goes further though. One of the things these cases talk about is a lot of times you'll see where lighting is not good or there's no security. And we realize that most businesses, they actually want to provide those things to keep their customers safe, to keep the people safe. But if they do that, how do you kind of get a reward to some extent? And what we've done is we've created a rebuttable presumption that if a business has the proper lighting, if a business does have security, if a business does have proper camera system, there is then a rebuttable presumption against liability. That is very strong, and it can only be overcome by clear and convincing evidence. So what we've done here is we've actually married the interests together. We want people to be safe. So we give an incentive for business actually to make people safe. If they do that, then the only way to actually be able to file that lawsuit is having a rebuttable presumption against liability. It can be overcome, but it has to be by clear and convincing evidence. The significance of that is when you start talking about frivolous lawsuits, a frivolous lawsuit would not get through that type of evidentiary standard. But a legitimate lawsuit would be able to get through that evidentiary standard. So the courthouse is not cut off. For a person who's trying to bring something frivolous, they would not be able to show clear and convincing. But somebody who has a legitimate actual claim, they will be able to still get to the courthouse. Also, we said, if there's a possibility, just because you're in a high crime neighborhood, we want you to have an affirmative defense. That by itself will not bring liability to you. I think we've done the perfect marriage here to make sure people are safe and at the same time also to help businesses continue to thrive or actually grow in those particular areas. And that's why we call it the Pro-People, Pro-Business Act. It actually brings the two interests together, which are not mutually exclusive. Businesses, we want them to thrive, but we also want to make sure people are safe. And we brought those two interests together in this particular bill. And with that, I'll answer any questions.
This bill has all kinds of provisions. What is it about the premises liability aspect of it that you guys decided to zero in on that?
All of it is connected. Make no mistake. Premises liability is connected with what they call phantom damage or anchoring damages. Everything is connected because it all goes to the courthouse. When we really look at our constituents and the people that we represent, we realize that a lot of our constituents, they're going to places like grocery stores. They're going to places that a lot of those times, sometimes those parking lots may not be as safe. And we realize that sometimes those businesses are having to pull out because of higher insurance rates. So what we said was, we know you want to keep people safe, but you're concerned if you do that, can a frivolous claim actually be brought against you? And this bill actually says it will be almost impossible for a frivolous claim to be brought against you. If you do the things that we all want you to do to help keep your customers safe, you will actually get a strong benefit, a legal benefit for doing that. And that's why we say we think this is a perfect marriage between the two interests. They were never mutually exclusive. We want businesses to actually have lower rates, but we also want people to be safe. Let's find out how to make those two things happen. We think SB 223 has done that.
Can you speak to healthcare in particular and how this bill or your position would impact patients who say they've been harmed on the operating table and doctors who say they've gone bankrupt?
This here deals with the premises liability aspect for third-party wrongdoer conduct, so where you've actually done a criminal action. So this is not goes into that particular part. We wanted to narrow this down because this is the one area that we had our biggest concerns with in that particular bill. And we thought this was an area that a lot of people were very concerned about. One thing we had to remember is, when we talk about premises liability and third-party wrongdoer conduct, which is interesting is the bill that the Republicans basically presented forth is trying to answer something which was legitimate cases. They're not addressing frivolous cases. They're actually trying to cut people off from the courthouse on legitimate cases. When we talk about the CVS case, that means it was an actual case where somebody was injured, the person was shot. When you talk about the Six Flags case, that's an actual case where somebody was actually beating to a coma. So these were real cases that happened. These were not frivolous cases. And that's what I found interesting about how the Republicans have approached this. They did not try to cut frivolous cases off. They're actually trying to cut legitimate cases off from the courthouse. What our bill does says is, no, we want legitimate cases to go forward. But if you have a frivolous case, it's going to be very difficult for you to get over these evidentiary hurdles. And that's how it should be. With that, thank you guys so much. Thank you.